20.
Please be seated.
Thank you, Judge.
Yes, sir.
Mr. Moulton, before the break, we had just entered into evidence exhibit 88, 89, 90, and 184. Before I ask you to take a look at those, did I make you aware that there was some sort of demonstration made regarding Griffin psychology?
Yes, you did make me aware of that from last week.
All right. And had you seen griffinpsychology.com before in your work in this case?
Yes, I found it early on. I found it at the beginning of the investigation that I was doing. It was one of the items that, when I was looking at content that showed they were going to start an LLC, I saw the development content, I saw Griffin Psychology with its development content on that. And, until last week, I never even knew it was going to be an issue because it seemed very apparent that that was a client.
Sure. And let me hand you D88. Will you just read off those few lines there from May the 12th in regards to Griffin Psychology from Ross's chats?
Okay. So, whoops, on the domain name, Griffin Psychology, the next line is Griffin Psychology /new site. I'll be removing unused CSS and JS tonight. And then, again, it's Griffin Psychology with a different spelling /new site.
What does /new site mean to you?
That they're developing a site, that they're physically going to develop content and have a display that's not on the primary page so that usually the client can look at it, or they have a space they can work on.
Okay. Was he sharing any information about jury trials or forensic interviews or anything like that?
No.
Preparing to testify? Or anything like that?
No.
Let's take a look. If you'll just read that line there from May the 14th at 2:55:49 for Ross.
To what time again?
2:55:49. The Griffin Psychology building.
If we so choose, my friend has given the okay to put Griffin Psychology into our portfolio.
Now, based on your review of the evidence that we had asked you to examine, part of that were the emails.
Yes, sir, that's correct.
Okay. Some of the emails, and you had extracted these that were moved into evidence D89, 90, and 184.
Yes, I did.
And these are from his Gmail account.
Yes, that's correct.
Ross Harris 00@gmail.com.
Yes.
Okay. Now, let me ask you to take a look at Defendant's Exhibit 184. What is the subject of that email?
Payment and instructions.
What's the date of that first email?
June 16th of 2014.
And what's the last email in that conversation there?
All the way here at the end. Is that what you mean?
Yes.
December 28th of 2012.
Okay, so there were emails between Ross Harris and Michael Griffin of Griffin Psychology from December of 2012 till June the 17th, 2014.
The 16th, yeah.
It's in the Defendant's Exhibit 184. Were there emails sent between Ross and Dr. Michael Griffin on June the 17th?
Yes, sir. This one is June the 17th, 2014.
Were they discussing jury selection,
No, sir.
forensic interviews, or anything like that?
No, sir.
Is this something that you just threw together the morning of your testimony?
No, sir.
Is this something that you just discovered yesterday or 2 days ago?
No, sir.
Get the lead. How long have you known about all this?
All the way back from shortly after I was hired, so somewhere last year in 2015.
Is this the context in which Ross was visiting Griffin Psychology?
Yes, for development. He was getting paid and there's many communications through email and Google chats, and then the site itself. I mean, the site itself actually shows up in a lot of different places. It shows up in regular content, shows up in the page file.
So this, what's already in evidence, it states 921. This little slide that was shown to the jury when Mr. Persinger was testifying. You see GriffinPsychology.com there?
I do. Oh, wait. Yes. Yes, sir. On the right-hand side, I see it. I see it on the left-hand side. Yes.
Does that give the full picture of the relationship between Ross Harris and Michael Griffin?
No.
If you saw that, would you end there?
No, sir.
Your witness.
I want to start by talking about some of your testimony for the defense. Let's go through some of those things real quick.
Yes.
But before we do that, you and I have had a chance to talk only twice, correct?
Yes, sir, I agree.
Okay.
I think it was fine.
You did have an opportunity to speak with Mr. Boring very briefly some time ago, correct?
Yes, sir.
Okay. The last time I tried to talk with you was this past Wednesday when my investigator and I called you. You recall that?
Yes, sir.
Okay. And you are a licensed private investigator. Is that accurate?
Yes, sir.
Okay. I assume during your private investigator training they have some training for you about report writing and documenting things. Is that accurate?
There is some content in there, yes, sir.
Okay. And you, I assume, over your career, at least created some reports and documentation of what you do in the past, correct?
Yes, sir.
And almost $20,000 you're getting paid by the defense in this particular case. That would include everything that you testified about here, correct?
I'm not sure I understand your question.
Okay. For the money that you're being paid for your services in this case, that includes your testimony here, correct?
It will once I build the remainder of it, yes, sir.
And also the work that you've done on the case over the hours that you spent assisting Mr. Rodriguez. Is that accurate?
Yes, sir.
Okay. Show me one piece of paper that documents what you have done in this particular case in terms of a report.
I do not have a report.
Okay. $20,000 and you have not created a single report in this particular case.
That's correct.
Well, when we called you Wednesday night and wanted to speak to you in advance of your testimony, do you recall declining to comment about your testimony with me and my investigator at that time?
What I recall is that I answered the general questions that you asked me, and then you started to get into some finite descriptions of things that I had communicated directly with Carlos and was items that I didn't feel comfortable discussing with you, mainly because I had seen in the search warrants where
I'm going to check all the search warrants, Judge. That's not relevant and it's not responsive to my question. So my question was, did you decline when we were asking about your testimony on Wednesday afternoon to speak with me and my investigator by phone about what you'd be testifying about?
I did answer a lot of questions that you asked, and I just didn't want to be misquoted.
Okay. And it wasn't until this morning, to your credit of your attorney, that we were able to navigate through that and that you were finally able to answer some questions for me. Is that correct?
Yes, sir.
Okay. Now, I want to talk a little bit about the subject of your testimony. from direct. I'll point just a few things out. We'll start with what happens to be on top for me. You showed State 604 and talked about this prison article, and you talked about clicking on some sort of huge video that's here, correct?
Yes, sir.
The article itself in 604 is not a parody, it's not a comedy. This is an actual article from Ask Men about what it actually is like in prison.
And it's under an entertainment section.
And there are actually interviews with actual inmates here, correct?
There are some, yes, sir.
And on page 3, there actually is a portion that talks about surviving in prison. Is that correct?
Yes, sir.
So I'm not going to argue with the
That's
semantics about it, but that is what the article is that was found, correct?
Yes, and it was in the entertainment section. Yes, sir.
Let me ask you about some other topics, because you talked about sports and things like that. You did see, I assume, the subreddit that was recovered from defendants' electronic devices involving death and being creepy.
And I'm not sure with regards to death which one you're talking about. If you have something to show me, I'd be happy to look at it. But I think I did see some content with regards to creepy subreddits.
Okay. And you are aware, and there's no doubt that there's an awful lot of sexual content that was recovered from the defendant's electronic devices.
Yes, sir. There's not a doubt about that.
You also did see the temperature video from the vet, correct?
I saw the vet video.
Did you watch that video?
I did watch that video.
More on that in a minute. Did you, by chance, see the emails that the defendant received from his wife where she was raising concerns about him leaving a child in a car?
No, sir. I did not see that.
Part of your work in this case was to examine these items, and you were not asked to review that piece of evidence?
I did not see that piece of evidence. That's correct.
You talked a little bit about the hazy video, and we'll come back to that in a minute. That's actually found on his iPhone 5 extraction. Is that accurate?
Yes, sir.
Now, are you aware that he only had that phone since November of 2013?
Yes, sir. I believe I am.
And as for the Lenovo, I think you covered this a little in direct, but I want to make sure that I'm clear on it as well. That Lenovo didn't come into operation for him until March of 2014, correct?
Yes, sir.
Okay, so we wouldn't expect the iPhone 5 to see anything prior to November of 2013, so that's when he began using it, correct?
Yes, sir.
And similarly, we wouldn't expect to find anything prior to March of 2014 on the Lenovo, because that's when we know that he began using it. Is that accurate?
Yes, sir. I agree.
Okay. Sticking on the topic of your direct examination, you were asked a question if you found any search for criminal statutes on his phone. Did you miss the statutory rape thumbnail and the age of consent when you examined the phone?
No, I believe I saw that there was a age of consent, I believe is what I just saw.
Okay, so when we're talking about searching criminal statutes and things like that, there at least was one search that we can be clear about, because we have the code section for statutory rape and the age of consent that was on a thumbnail on the phone.
Yeah, on the thumbnail I saw a age of consent.
All right. Let me ask you about some of the sex activity in the phone. You were able to say that from a forensic perspective, and I put that in quotes, from a forensic perspective, you didn't find it very hard to find whisper and kick and all of those types of apps. Is that correct?
Yes, sir.
Have you ever accessed the phone?
The original phone?
Yes.
Sir.
You never looked on that phone at all?
I've never seen that phone.
If I asked you right now, where is that whisper app? Where is kick? Can you articulate for us where specifically that is?
I only know that it was in this folder. I don't know where it was.
Okay. And, of course, if you are a computer guy such as yourself, it might be a little bit more difficult for a layperson such as a wife to be able to find that app, particularly if it's under the weather section.
Yes.
Okay. The shadow copy that you talked about, when I asked you about that this morning, that was the first time you raised that with us. Is that correct?
Yes, sir.
Okay, so staying on the topic of the shadow copy, you articulated two dates that you saw there, June the 17th and June the 13th. Is that correct?
That's correct.
Are you aware that those two dates are after the manual purge of June the 6th?
One of them, yes, that's correct.
June 17th and June 13th is the dates that you gave.
But, no, I understand that, but I think that there might have been a question about how many purges that there were, but yes, sir, I agree.
June 6th was the manual purge date. You agree that those two dates come after June the 6th?
Yes, sir. I do.
I want to ask you a little bit about what your testimony was about a program to delete content. You testified that you didn't find that, correct?
I did not find a program that I thought was used to delete content.
The difference between a program to delete content, though, and settings that might be set up in on a web browser that would automatically purge data. Is that correct?
I'm not sure what the question is.
So if your settings for Google Chrome, for example, were set to automatically purge every 90 days, that's not technically an app, but that is a setting that can be set up on the computer through that website.
Sure, absolutely. Not website, but application, yes, sir.
And of course, the data that we find on extracted devices is not the exclusive story. You mentioned a couple times data overwriting, correct?
Yes.
Since you brought that up, I want to make sure that the jury knows exactly what that means. When you have an electronic device, in order to save space over a period of time, some data is eventually going to be overwritten by new data. Is that accurate?
Yes, sir, it is.
And it's not always capable. We're not always capable of getting that data, particularly if it is overwritten.
Absolutely not. You cannot. After it's overwritten, it is gone.
Now, you left off with your directs by talking a little bit about Griffin's psychology. Are you aware that these were used as demonstrative aids? In other words, examples of something during the testimony in this case?
I was made aware of it last week, yes, sir.
Okay. What demonstrative aids have you prepared for court today?
None.
If you wanted to, could you have gone back and made a demonstrative aid and used some sort of example, whether it's Griffin, psychology or whatever? Is that something you're capable of doing?
Yes, sir.
Have you made demonstrative aids for court before?
I've certainly made reports. Yes, I believe I've made a demonstrative aid before, yes, sir.
Let me ask you this. I noticed that you had a list of cases that you've worked on in your CV. Most of those are civil cases, is that correct?
There are some criminal cases, yes.
For the criminal cases, have you ever worked as a prosecution?
No, probably not.
All right. You've only testified as a defense expert, is that accurate? Or in a civil context?
I've done affidavits for prosecution before.
The forensic work that was done in this particular case, Cellbrite, you're familiar with that?
Yes, sir.
N-Case, you're familiar with that?
Yes, sir.
Internet Evidence Finder, you're familiar with that, correct?
Yes, sir.
VPN, you know what a VPN is, correct?
Yes, sir.
And you as a web developer are familiar with all of these things and familiar with how you develop websites yourself, correct?
The basics of, I don't do it every day, but yes, sir.
Do you have subscriptions to all of these things that we talked about, Cellbrite, N-Case, and IEF in particular?
Yes.
Okay. And it's not remarkable in the least that forensic analysis units might use these. These are pretty standard things that you use within the industry, correct?
Yes.
And periodically you're required to update those to make sure that they're accurately parsing through data as apps are being developed and updated as well, correct?
But you don't have to update, you don't have to buy new versions, or at some point in time if you're happy with where you're at, you don't necessarily have to purchase the new version. But yes, sir, you can if you choose to.
I want to talk about a little bit about the manual purge here. You testified that as a web developer that you didn't find that to be terribly significant. Kind of gave an example there. That's one reason why you might want to do a purge, like an intentional purge of your account. You agree with that?
Yeah, I've also seen it when people go to a lot of porn sites and they want to make sure their wife or somebody can't find that as well. But on his work computer, he wasn't going to porn sites as best I could tell.
Okay. Well, let's talk about that. One of the things we could do is we could actually look at the Lenovo itself, and we've done that, and we have that data that's been recovered, correct? Mm-hmm. Another thing we could do is we could look at the other circumstances surrounding how he's using his electronic devices. Is that accurate?
Yes, sir.
Okay, so I'm going to show you State's Exhibit number 51 by way of example. We can look through this together if you don't mind.
Sure.
This is Defendant's 51. Do you recognize this as being the web history from the iPhone 5?
Yes, I've seen this information before.
I've got my copy of Defendant's 51 in front of me. I'm going to start on the back page. You see, for example, CDC, sexually transmitted disease. That was included in that web search, correct?
Can you show me where you're looking?
Sure.
Yes,
45?
I got it. Yes, sir. That's correct.
How about psychopathia sexualis in line 42? Do you see that?
Yes, sir, I do.
Okay. There's another CDC entry in line 39. Do you see that as well?
Yes, sir.
We have a Google search for inappropriate. That's the word on line 34. Do you see that?
Yes, sir.
Land casual encounters, W4 Craigslist, line 29. Do you see that?
Yes, sir.
All right. And then we've got Young and Wild, line 26. Do you see that as well? Is that third page?
Yes, sir.
Let's skip on up to the top. We've got Atlanta Casual Encounters Classified. That's actually got a date stamp on it. Is that correct?
Yes, and additionally, I mean, I'll tell you, in his email, there was also a lot of content from Craigslist and pictures and things like that as well.
Sure. Then we've got number 4. That's the wire, hot and humid dates, often hazy, correct?
Yes, sir.
All right. For this content that we have in terms of the web history from the iPhone 5, defendant's phone recovered by Officer Piper, what are the dates associated with it, where there are dates?
On the first page, 6/17, 6/18, and then there just aren't on the others.
You agree that the only dates that we have associated with web searches from the iPhone 5 are from the 17th and 18th?
Yes, sir.
Okay. And why are hot and humid days often hazy? What's the date and time associated with that, please?
That is 6/17, and it is showing at 9:12:56 a.m.
That's June the 17th of 2014, correct?
Yes, sir, that's correct.
And we've had a discussion. You were at least kind enough to talk with me about UTC when we spoke on the phone this past Wednesday, correct?
Yes, sir.
You believe that the Cobb Police and person here got that right, where we need to be UTC -4 because of daylight savings time?
Yes, this says -4, but yes, sir.
All right. And then the Atlanta Craigslist, that's June the 18th of 2014 at 2:50. Is that correct?
Yes, sir.
So, in terms of looking at, why somebody might be deleting their history from a laptop, we can certainly look at other electronic devices to see if there's a comparison, correct?
Oh, yes. Yes, sir.
Please identify any Home Depot usage from that iPhone 5 web search that you see. Let me flip it around. Would it be surprising for you to know that there isn't any?
No, it's not surprising.
Okay. So one of the things we could do is we could look at other electronic devices and see what sort of history the defendant is using. That might be instructive when we're talking about this issue, correct?
And certainly on his MacBook as well, he had porn, so
Sure.
he was looking at there.
I want to ask you a little bit about the web developing that you've had some experience dealing with. You've built websites before, correct?
Yes, sir. I've done some basic websites. Yes,
The
sir.
exclusive way of clearing the cache is not the deletion of web history. Would you agree with that? Let me ask you this. What's F5 on the laptop? What's F5?
Normally a refresh.
Okay. And what's Control F5?
I'm not sure. It depends on the application.
So as a computer specialist, you're not familiar with the fact that Control F5 automatically updates your cache so that you don't have to delete your web history?
No, I'm not familiar with that.
You've never heard of that in your experience?
I just haven't used those particular keys necessarily.
Okay. So if that is the case, that F5 refreshes and Control F5 updates the cache, it certainly would be possible that you could do that update without deleting your content history.
If what you say is true, then I agree.
Okay. Another reason we might want to look around, say, on an electronic device in terms of whether there's intentional deletion for other purposes, we might want to ascertain, for example, where specific apps are to see if there's any evidence that the defendant is acting covertly with how he keeps things on there, correct?
Okay. Yes, sir.
Would you agree that you're probably in a better position to be able to find apps on a phone as a forensic expert than most laypersons such as the members of this jury and even myself?
We would do that from, like Celebrite makes an image, and then we would parse the data from that, and we would be able to see the apps that were on the phone. We generally aren't looking at the phone live in most cases, but
Did you ask to do that in this case?
to look at the phone live?
Yeah.
No, sir, I did not ask to see it live.
I want to show you two particular extraction reports, one of which is already in evidence, State's Exhibit 631, and you looked at that with me this morning, correct?
Yes, sir.
And then I'm going to show you states 936 as well. I showed it earlier to you this morning. It's a extraction, a whisper post from the date in question, 10-936.
No objection?
Yes, sir.
Well, consistent with the objections that we had originally made, Judge.
I'm sorry.
Just consistent with the objections that we had previously been making to the electronic evidence found on the phone.
That is for the record, you can proceed.
I'm sorry, could you restate your question?
You recognize these as both being reports that were generated, particularly whisper chats that were extracted from defendant's iPhone 5.
Yes, sir, I agree.
Okay. I'm going to ask you some specific questions about that. Looking at State's Exhibit 631 first, which is already in evidence. The time, first date, and time stamp that we have there is what?
So that says, the date says it's 6/18/2014, and it's -4 UTC, so it's 10:46 and 34 seconds a.m.
And you agree that that's an accurate statement at the time of that history, correct?
I definitely think that cell phones are pretty accurate on their dates and times. As, like I said, I haven't seen the original device, but I have no reason to doubt that.
Looking at 936, I'll refer to that as the PCB or Panama City post. What's the time associated with that in terms of the defendant's first response to that?
6/18/2014 at 9:49:01 a.m. -4.
All right. So if it were asserted, say, an opening statement that for 631, that occurred at 8:46, that would not be accurate. It's actually 2 hours different, correct?
If that's true, yes, I would agree.
And similarly for 936, if it were asserted during someone's opening statement that occurred at 8:49, that would not be accurate, would it?
Right, I would agree that if somebody said that, yes, sir.
Understanding that there's a distinction between searching and clicking, you understand that distinction, correct?
Yes, I believe so.
Okay. And I'm not going to certainly argue any semantics with you or anything about the actual video that you saw. We'll refer to as the hot car vet video. You're familiar with that one, correct?
Yes, sir.
Okay. Whether it was accessed twice or once, it certainly shows twice, correct? That's what the report
says. It was accessed twice with 1 second difference.
But there's no doubt, though, that it was at least accessed once, correct?
Yes, sir, that's correct.
And you're familiar with the fact that that requires an actual clicking. It does not autoplay, correct?
I agree with you. Yes, sir.
There had to be some human activity in order to be able to access that video and be able to get it to play.
Yes, sir. You definitely clicked on the video and watched it.
And so we're talking about really 2 separate actions here, because it's the first looking at the Reddit, and then from the Reddit clicking on that taking you to YouTube, correct?
Yes, it was from Reddit and then launched YouTube.
So, but a manual user would have to actually use a mouse.
He did click on it and he did watch it.
And of course, if he admitted as much to the police as well, then whether it was once or twice, I mean, that really wouldn't matter as much. It's an admission. Would you agree?
Yes, if he admitted that he watched it, then yes, and it seems to correlate with the evidence. He did watch it.
Okay. And then in terms of the divorce, did you find that divorce activity from May the 9th?
Yes, I found a divorce checklist.
Right. And that divorce checklist, just like we've talked about with the video, requires a manual click by the user in order to get there, correct?
It does appear that there is a manual click. I believe there was also a second time that item showed up as well. I believe it showed up again on May 13th. I didn't find any content from the page on the device, so I didn't find any other items that showed up as the divorce content, but I did see divorce checklist on the, it's the Home Depot HR site, so on the HR site, he saw that.
All right. And then in terms of the particular whisper post that's of significant interest here, 399, and of course the conversation 400, you saw this whisper post about I hate being married with kids, the novelty is worn off, correct?
Yes, sir.
And you also saw his response which began at what time, please? Looking at states.
Yes. So this is at 6:18:14, and it is at 8:55 and 19 seconds a.m. UTC -4. So it appears to be correct.
All right. And specifically, I miss having time to myself and going out with friends. That's what the defendant responded to this post, correct?
That is correct.
And then the next time he responds, my wife gets upset when I go out with my friends. And then shortly after there, I love my son and all, but we both need escapes. What are the times associated with those two messages for the whisper post?
Those are again on the same day at 9:15 a.m., 9:15 and 15 seconds a.m., and again 9:15 and 33 seconds a.m.
And what is the last time the defendant responds?
The last time is he says we both need that, and it says at 9:24 and 28 seconds a.m. UTC -4.
So in this particular case, you're aware that Cobb Police found illicit messaging, correct?
Yes, sir.
Persinger found the illicit messaging, correct?
Yes, sir.
You found the illicit messaging, correct?
Right away, yes, sir.
Okay. In terms of the divorce, that was recovered by Cobb Police, correct?
I saw it in the list, yes, and I saw it myself as well in my searches.
Persinger discovered that, and you did as well, correct?
Yes, sir, that's correct.
In terms of the video, the vet video, police found that video. You're aware of that, correct?
Yes.
Okay. Persinger found that video, and you too found that video and can confirm for us, correct?
Absolutely.
And that video was viewed 5 days prior to the defendant leaving his child in the car.
Yes, sir.
And that final whisper post that we just looked at, Cobb Police found that whisper post. You're aware of that?
Yes, sir.
Jimmy Persinger found that whisper post, correct?
Yes, sir.
And you can confirm that you also found that post from the morning of June the 18th, 2014 as well.
That's correct.
Just a moment, Judge. Did you see the Reddit subreddit involving the death comments that we were talking about watching people die and morbid reality? Did you observe those?
I do recall seeing the first one. I'm not sure if I saw the morbid reality, but I do, now that you say that, recall seeing the subreddit. Yes.
So when I was asking you questions about an interest that was being shown on Reddits and subreddits, you at least can confirm, in addition to the video that we talked about, we also have this Watch People Die that was on a subreddit.
Yes.
Okay. Just not sure about the morbid reality.
Right. I'm not. I just don't recall every entry. If you have a report or something, I'd be happy to look at it.
So I don't think that's necessary. We have the actual extraction and everything.
Okay.
Thank you.
Thank you.
Yes, yes, ma'am.
You don't know if Ross was interested in subreddit or had subscribed to the subreddit or some group of Watch People Die or anything like that?
I don't recall seeing that in a subscription or anything from that standpoint. No, I don't recall that.
Did he click on a bunch of random topics?
Yeah, all the time.
Would he cut and paste links to his buddies while they're chatting to try and one-up each other?
Yes, they would send constant stuff back and forth to each other, jokes or whatever else. Yes.
Some tasteful, some maybe not so much.
Correct. There's some not tasteful.
Okay. Before this case, were you familiar with some of these sites, videos?
Yes. I mean, I've seen. I don't know if I specifically saw like morbid, deaths or something like that. But I've used Reddit before, and I've seen the list of things before. Yes.
The whole point with Reddit, right? It gives you a bunch of topics, random topics, right there for you to look at.
Yes,
Object to argumentative. Then I'll add Lee.
But I'll give him some attitude.
Yes, ma'am.
I can rephrase it. We can streamline it. Does Reddit allow you to look and explore at a bunch of random topics?
Yes, it is. I mean, it's a user-based site, so they post whatever content is on there, and you click on things that you like, and it pushes things up, and there's a lot of community lists and things like that.
Can you click on things that you don't like?
Sure.
That you don't approve of?
I mean,
Right?
right. I mean, it's other than the fact that it's user-based, I mean, it's not a lot different than something like CNN or something where there is, you don't have to click on something you don't want to see. You don't know all the time sometimes when you click on stuff what you're going to see.
You were asked why you didn't make a demonstrative aid in preparation for your testimony. You're aware that this was shown to the jury as a demonstrative aid.
Yes, sir.
You're aware that there was testimony about Ross being crafty and Dr. Jekyll and Mr. Hyde.
Yes.
And I made you aware that this was shown to the jury to suggest that Ross was trying to hide his internet activity. Can you tell us about that VPN tunnel and what VPN is?
VPN is a virtual private network. It's really used to secure point-to-point connections. And so, as an example, my girlfriend is a nurse, and in order to update her calendar or in order to look at stuff, she has to log into the hospital's website through a VPN tunnel. As a person who managed IT services and computers for a lot of clients over the years, some that were lawyers, some that were medical and financial, we've had to set up VPN tunnels so that people who are working at Starbucks or someplace like that had a secure connection to their equipment so that someone else didn't scarf the data while they're in the location using it and trying to do identity theft and a bunch of other things. So it comes up a lot from that standpoint. It's a security thing. And, even Home Depot, as I understand it, has a VPN for the people to connect in and work remotely or do something from that standpoint. So it's not unusual at all. I've used them, I've set them up, and we've been through this before. It is the secure way to do it. That particular site it's a pretty popular site as a whole, mainly because of its speed. If you're using a VPN tunnel, you want to make sure that you have a pretty high-speed connection, and this particular one does supply that. But there are issues with regards to if you're going to work on a medical client like Griffin Psychology or somebody like that might have HIPAA issues or HIPAA violations that maybe you're shopping around for a VPN client or VPN tool. And as I understand it, that particular tool, that particular website is not HIPAA compliant. It is not, and so I don't know if Ross found that out or looked at it, but it may be that he was just shopping or something along those lines.
Speculation.
But it is not a HIPAA compliant site.
It's not HIPAA compliant.
Right.
Did Ross purchase that service?
I don't know for sure, but I did not see any other content related to it to show that he had purchased it.
Did that website ever pop up on anything that you observed?
No.
Did you create anything before this jury to mislead this jury?
No.
Was it your intent to mislead this jury with any testimony that you were offering?
Absolutely not.
In terms of misleading the jury, do you agree that the best way to ascertain when a device is being used is to look at the content that's on the device?
Yes, sir.
Okay. So if there's a question about whether a phone, for example, which can be used for benign purposes, is being used for some illicit, we could look at the phone, correct? That would be the best evidence.
Well, I don't know if you mean the physical phone or do you mean an
Extraction.
So I'm looking at the extractions. I'll have to look at the extractions, the copies of the phone.
While laptops and computers and electronic devices can be used for all kinds of purposes and aren't so sinister and things like that, they can also be used for very bad things too. You know that in your experience, correct?
Absolutely. Yes, sir.
And perhaps the best way, so we're not misleading anyone, would be to look at the extractions of those actual devices. Would you agree?
Yes, sir.
Thank you.
You can step down.
Thank you.
Yes, sir.
I'll do that, sir. Yes, sir.
You need to vote.
Please.
I need to ask you to step outside and take another little break, which I know y'all do since it's a day.
It's all right.
Keep it up in mind, don't discuss the matter.
Please watch your step going down.
And we're moving at a proper pace, so don't worry. We're moving at a proper pace. It's important. It's important to know.
Please be seated.
We're going to have the bench conference. We're going to take a recess for the defense to take next steps in moving the case along. And we'll have a report back in how long we anticipate.
15 minutes.
All right, we'll anticipate 25 to, but if you need a little more time, let the deputy know. And the deputy will let us know, and we'll work with you.
Okay.
Let's take a recess.
Okay.
Don't say no profanity now. I think it's you need.